Typically, adult patients have the authority and ability to make their own healthcare decisions. But what happens when a patient loses the ability to decide and they haven't identified in advance who should take over? This video explores the ethics of substitute and surrogate decision making in healthcare. Healthcare focuses on the interests of the patient. Normally, when making medical decisions for an adult patient, we ask the patient directly what they would want, and if their requests are medically reasonable, we try to honor them. But some patients cannot express their wishes due to illness, injury, or cognitive impairment. In these cases, someone else must step in as a decision maker. In emergencies, where there's no time to get consent from someone who knows the patient, physicians may act without explicit consent. But in non-emergent cases, the authority to make decisions does not fall to the physician, and instead, a substitute decision maker must be identified. Substitutes fall in three categories. First, agents. Agents are those chosen by the patient in advance, through documents like durable power of attorney for healthcare or just direct verbal statement to the provider. Second, surrogates. Surrogates are identified by providers when no agent exists, often guided by state laws or ethical norms. Third, guardians. These are appointed by courts through a legal process with authority defined by law and judicial oversight. A patient-identified agent is discussed in the video about advanced care planning. Here, we focus on surrogate decision makers. In everyday language, a surrogate is anyone who speaks for someone else. But in this video, we will use the term specifically for someone appointed by a provider to make decisions for an incapacitated patient. Some systems, like the Veterans Administration, and certain states, require providers to identify a surrogate by following a strict, what we call next of kin hierarchy, starting with spouse, maybe adult child, then parent, adult sibling, and so on. Other states, however, allow more flexibility, letting providers choose someone, like a close friend, if they are best suited to represent the patient's wishes. Ethically, a good surrogate should demonstrate the following characteristics. They should have decisional capacity themselves. They should know the patient personally and care about their well-being. They should be familiar with the patient's values and interests, and also be willing to express those patients' wishes, not their own. They should be reasonably available for discussions with the team, and be willing to take on responsibilities of the role of substitute decision maker. While a family member or friend has their own special relationship to the patient, if they are appointed as the patient's surrogate, they take on a specific set of moral expectations as the patient's surrogate. They should follow any explicit instructions the patient gave, verbally or in writing, regarding their healthcare interests. And if no explicit instructions exist, the surrogate should use what has become known as substituted judgment. That is, they should decide based on what they believe the patient might have wanted, given the patient's life story, given the patient's known interests, and given the patient's values. Finally, if the patient's values are unknown, the surrogate should choose what is medically best for the patient, focusing on optimal benefit and comfort. It is important for providers to help surrogates understand this special role that they are taking on and the responsibilities they have in that role. In some cases, a patient may already have or be assigned a guardian. Guardians are appointed by courts and often hold overriding authority, even over the patient themselves. Their powers are defined by state law and court orders. In some cases, guardians cannot make certain decisions, such as withdrawing life-sustaining treatment, without getting court approval. Always check the legal requirements of guardianship decisions before proceeding with care plans. Not all patients who have or need a substitute decision maker lack all abilities to participate in healthcare decisions. Sometimes, patients who lack full decisional capacity can still express preferences. These should be taken seriously and included in discussions. However, if preferences are medically unreasonable or conflict with the patient's known values, the surrogate or guardian and the care team must weigh them carefully in light of all other considerations of the patient. Substitute decision-making should attempt to promote patients' values and interests as a guide to their care, even when they cannot speak for themselves. Whether through agents, surrogates, or guardians, the goal is always the same: to honor the patient's life story, values, and dignity. In Arkansas, several statutes govern medical decision-making. For our purposes, we will focus on the Healthcare Decisions Act, passed in 2013 and updated subsequently. While not the only law in this area, the Healthcare Decisions Act is often the determining statute in healthcare decision-making. The Healthcare Decisions Act begins with a simple principle. Adults are allowed to make their own healthcare decisions. But if an adult lacks capacity, the medical team must look to another person to decide on their behalf. The law recognizes three types of decision makers: agents, who are chosen by the patient in advance; surrogates, who are identified by providers when no agent exists; and guardians, that are appointed by courts. Importantly, an agent or guardian takes legal precedence over a provider-identified surrogate. When identifying a surrogate, the Healthcare Decisions Act directs providers to consider the following: the person's ability to decide based on the patient's wishes or best interest, their frequency of contact with the patient before and during illness, their demonstrated care and concern for the patient, and, optionally, their availability to visit and fully participate in decision-making. The law suggests an order of preference in identifying a surrogate. It would start with spouse, adult child, parent, adult sibling, other relatives, and finally, another adult who knows the patient and meets the criteria. But this order is not mandatory in the law. Providers are encouraged to focus on the person best suited to represent the patient's values and interests, not simply who is next of kin. Some patients have no one who meets the criteria to serve as a surrogate. Such patients are unrepresented. In such cases, the Healthcare Decisions Act allows the supervising provider to make healthcare decisions, but only after first consulting with the institution's ethics officer or ethics committee, or second, obtaining agreement from a second independent physician not involved in the patient's care. The Healthcare Decisions Act provides a framework for ensuring the patient's values and interests guide care, even when they cannot speak for themselves. By balancing legal guidance with ethical responsibility, providers can make decisions with clarity and compassion. Both UAMS and Arkansas Children's Hospital have policies that guide medical decision-making. These policies are rooted in Arkansas law, particularly the Healthcare Decisions Act, though they are not limited to the provisions in that law. When a patient cannot make decisions for themselves, institutional policy follows the same process and criteria outlined in the Healthcare Decisions Act for identifying a surrogate. Importantly, the policies at UAMS and ACH specify that it is the attending physician, not another licensed independent practitioner, who determines the surrogate. In cases where a patient is unrepresented, meaning no suitable surrogate can be identified, and the decisions involved end-of-life care, UAMS and ACH policies add an important safeguard. They require that both a second physician and an ethicist weigh in before moving forward. This ensures that decisions are made with careful consideration, transparency, and ethical oversight. By aligning with state law and adding institutional safeguards, UAMS and ACH policies ensure that healthcare decisions are made responsibly, ethically, and in the best interest of patients.